So here it is, guys, the distinction framework. So if you're a student who's stuck in your 40s or 50s and you're doing everything in your power and you don't seem to understand why you're not crossing that 50 or even that 60, this distinction framework is going to help you immensely. I have 5 distinctions in my University of London examinations, and I will tell you the tips and tricks that I used, and this will be really helpful for you in your examinations. So first things first, you're not getting your desired score because you lack the knowledge. It's because you aren't attempting or you aren't answering the question that the examiner wants you to answer. So most students stuck in the 40s and 50s are not because they don't know the law. They're stuck because they're answering a different question than the one the examiner is asking. Examiner doesn't care if you know the law or not. The examiner has arguably 300 scripts that he has to mark, right? And all he will see in all of these scripts is the same law repeated again. The law will stay the same for every single student in the examination. So that's one thing that will not change. What will change is the way that law is applied. What will change is what you make of the law. That's what's important. So the real question on every exam paper is, can this student see the law the way a lawyer does? Now that's the gold mine. When you see a question in the examination, you should always see that question from a lawyer perspective and not from the perspective of a layman who is reading the question. Now I'll give you a lot of examples in this distinction framework as well as we go through it. So the first technique that I will give you to get you your desired grade is the critical analysis. Now this is a buzzword that has circulated in almost all examinations, but what does this actually mean? So critical analysis is you looking at the law in a manner in which only you see it. So if I ask you a general question, for example, if I ask you, what do you think about the law of contracts or the law of offer and acceptance? Now, there is a general framework that every student has in their textbooks and their guides. But what do you make of the law? Do you think that the law is in need of reform? Do you think that the law is perfect in the way that it is? Do you think that the regulation needs to be stricter? Do you think that the law needs to be revamped altogether? Do you think that a new law has to be passed? That's critical analysis. That's you critically analyzing the law. That's what gets you 70s. Not you stating what the law is and not you giving the examiner the case laws. So critical analysis does not mean criticizing. That's one of the biggest distinctions. I've taught over 800 students in my life, and this is one of the biggest problems that most students face, is that they think that critical analysis means criticizing the law. That's not what it means. It means that you look at a legal rule and you ask yourself simply one thing: why does this rule exist? What assumptions does it rest on? Where does it break down? So if in the exam you get a question and you want to analyze a law, these are the 3 questions that you need to ask yourself for critical analysis. Why does this rule exist? Why does the rule of offer and acceptance exist? After that, what assumption does it rest on? That's what you're looking at. Does that assumption make sense as of 2026? Where does it break down? So what is the issue in the law? If there is no issue in the law, the examiner is not going to ask you the question. So what is the issue in the law? Now let's look at an example, a comparison between what a student who's got 50 marks, how does he apply the law, and a student who gets a distinction apply the law. So how does a 50 grade student think? The rule in Carlyle versus Carbolic Smoke Ball is that an advertisement can be an offer if it is sufficiently certain. Therefore, the claimant can enforce the contract. Now, this is a simple application, and you are simply stating what the rule is. Why this is good? This is a good starting point. This is not how you are supposed to analyze the law. Now, how should you do it? The rule in Carlyle assumes certainty of terms is the distinguishing factor. But why? This protects promisees from deception. Does that reasoning hold in digital contracts where terms shift dynamically? Now, if you look at it, this is critical analysis. they have introduced a completely new term known as digital contracts into the conversation, and if an examiner is reading this, that examiner is going to be blown away. And when an examiner is blown away, 70, that's where you get it. Now what's the formula? Now I told you what critical analysis is, I told you how to go about this. Now what is the formula? So first of all, you always start by stating the rule. You state what the rule is. So in this situation, Carlyle versus Carbolic Smoke Ball, you state the rule that it is an advertisement can be an offer if it is sufficiently certain. You've done that, then you identify the purpose behind it. Now why has the judge in Carlyle versus Carbolic Smoke Ball decided the law in the manner that they have decided the law? You state the purpose behind it. Then you challenge the case where the purpose breaks down. So again, there is some issue in the law, which is why you are getting examined on this area. If there's no issue in the law, you're not going to get examined on that area. So challenge a case where the purpose breaks down, and then you give him a nuanced conclusion, which means that you give him a conclusion that you think is legally correct, and here is where your legal lens, where your legal mind comes into place. For example, I'll give you another example. Folks versus Beer. I have intentionally given you only examples of contract law because you study contract law in your A-levels examinations. You study this, it's in your first year of your LLB, University of London LLB, or University of Hertfordshire LLB, or Nottingham University, or whichever UK curriculum you take. Contract law is usually in the first year. So the rule in Folks versus Beer holds that the part payment of debt cannot satisfy the full amount owed. The purpose is to prevent, here you go. Now they have stated the purpose. The purpose is to prevent coerced waivers of rights. Now, a person who wants to get a distinction has to state the purpose. Somebody who's probably getting a 50 will probably and most likely not mention this. But this is very important. This shows that you have a legal mind. However, as Lord Blackburn himself acknowledged in dissent, this produces commercial absurdity. Now, it's a work of art. We've used the text from Lord Blackburn and we have broken it down into what Lord Blackburn thought was the error in the law. So that's excellent. A creditor who voluntarily agrees to accept less receives no equitable protection. The doctrine has since been partially eroded by promissory estoppel in another case, which is the Central London Property Trust versus High Trees. Again, in this lecture, we are not going to go into the law. I'm just teaching you how you're supposed to write the law. So now notice the student names the tension. So the student has clearly, now the student who writes this, he gets a 70 because he notes down what the tension is. The tension is that Blackburn himself acknowledged in dissent that this could be commercially absurd. And then secondly, another point of tension is that promissory estoppel, another doctrine, has partially eroded the application of Folks versus Beer. So this animosity that is being created, expressing this animosity gets you the grades. So now he states the tension, then he cites judicial doubt. He has explicitly, he hasn't given anything that's out of the blue. He's not giving his own opinion. He is giving you judicial dissent. He is raising judicial doubt. A judge has raised these doubts. So he uses that to build authority and then connects it to a related doctrine. That's exactly how you're supposed to do it. Another thing that I would probably add here is that I would just add a sentence to follow the last sentence by stating what my opinion on that case would be. So that would make this a 70 plus answer easily. In this current state, it is a 70 answer. If you look at somebody who's stuck at a 50 or a 60, they're probably just stating what the law is and then moving forward. Okay, this is the technique that I've used, and there are generally 5 frameworks, of which this is the first framework that we're discussing. 5 frameworks, but arguably the most important part of a framework, the jurisdictional analysis. Jurisdictional analysis got me marks every time. Even if I did not know the law, jurisdictional analysis is what got me the marks. Now, what does jurisdictional analysis actually mean? So jurisdictional analysis means, as you can see on the screen as well, jurisdictional analysis is you comparing 2 jurisdictions with one another. So it can be as simple as comparing the UK law with the US law, or comparing the UK law with the law in Singapore, or comparing it with Bangladesh, or comparing it with Pakistan, comparing it with India, and stating what the rule is in the UK and what the rule is on that topic in, let's say, the US. So let's say the competition law rules in the UK are so and so. I'll follow that up and I'll say, so a 50 student who is getting a 50, he will merely state what the UK law says, that the UK competition law code says this, full stop. If you want to get that 70, and if you're struggling to get that 70, what you need to add into this discussion is what another jurisdiction is saying. Now, how do you choose that jurisdiction? Which jurisdiction to target? My rule of thumb is always choose the jurisdiction that is analyzing the law better, that is using the law better, that is enforcing the law better. So if you think that the competition code in the US is better than it is in the UK, then you compare it with the US. That's what jurisdictional analysis here means. You can look at the examples on your screens. I have again stated an example of the chapter of third parties' rights of contract law. So you can have a look at this. If you want this distinction framework, you can comment distinction framework down below, and I will send this to you through your email. So now let's look at a side-by-side comparison of what a 50 answer and what an answer that is graded as 70 looks like. So now let's look at a question first. So the question says, critically evaluate the doctrine of consideration in English contract law. Now the person who's got a 50 will answer the question like this. And if you are somebody who has this writing style and is relatable, you must look at the answer that's graded as 70. So the 50 graded answer would say, consideration is a necessary element for a binding contract in English law. The leading case is Curry versus Misa, which defines it as a benefit to the promisor or a detriment to the promisee, so on and so forth. You can read it. It's a simple, although it's correct, it's authentic, it has case law names, it has case law dates, it is analyzing the law correctly. And at this stage, when the student has written all of this, he feels or she feels that, I've done so much. I've written the case laws. I have given the dates of the case laws correctly. I have given 5 cases to prove 1 point. That's what's wrong. That's what you don't have to do. I always say this. It's not the number of cases that you give in the exam. It's how you give those cases. If you give 1 case and you apply it in 3 ways, that is 100 times better than you writing 3 cases and just simply listing them. So now let's look at the grade that got a 70. Now you can look at the first paragraph, which will resemble the one who got a 50. They're very similar to one another. But here's where the game changes. French law under the Reformed Code, Civil Article 1128, does not require consideration as a distinct element. So now you're giving him a code, you're giving him a jurisdictional analysis of an area that does not even have consideration as a requirement. What better way to criticize or to critically analyze the law than by giving them a jurisdiction which does not even consider jurisdiction an important part, that does not even consider consideration as an important part. So that's how it's done. Now this is obviously research driven, but the use of artificial intelligence and AI is easily, you can get all of this information within 2 to 3 minutes. So I don't want to listen to you saying that this takes a lot of time, because it doesn't. So all in all, the person who got a 50 or a 52, he knows the law, he applies it correctly, does the bare minimum. The examiner is reading 300 scripts. In all of those scripts, he's reading what Folks versus Beer is saying. He's reading what Carlyle versus Smoke Ball is saying. He knows what the law is. He knows what these cases say. He doesn't care. What you need to do is you need to make that distinction. It's called distinction for a reason. You have to give him that extra knowledge. You have to go beyond the bare minimum. So now I have a checklist here, a quick checklist that you need to follow, and that's how you would know whether your answer would fall into a 70 or a 50. So Have I named the purpose of the rule? Whenever you're stating the law, have I named the purpose of the rule? If you have, you move on. Have I identified at least one point where the rule fails to achieve that purpose? You identify that one shortcoming of the rule. Have I used one other jurisdiction to show the English approach is a choice, not a universal fact? This could be any jurisdiction such as the US or the French, like the ones that we used above. Does my answer end with a position? That is, what is your stance on this? You say the UK framework says this, the French framework says this. That's not the end of it. You need to give your opinion. You need to take a position at the end. I believe that this is what the correct law is. I believe the French law is correct. I believe that the French law is partly correct. The French law needs to be incorporated into the UK law and it needs to be made better. That's what gets you the 70. And what you need to be careful of is that, are you just stating what the law is? That, and is my jurisdictional comparison purely descriptive? Am I just telling them that some other jurisdiction does this, not applying it to the facts? Then you're not going to get your 70. So this is it, guys. This is the complete framework that I wanted to discuss today. This covers two fundamental techniques: critical analysis and jurisdictional analysis. There are a total of 5. Comment distinction framework down below, and I will send this framework to you for free. If you want to get a hold of the other 3 techniques that are left, you can DM me on Instagram, or you can email me in the description box below, and I can send them to you as well. So take care, study hard, guys.